Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Melone Hatley PC, and this is our weekly podcast, I Now Pronounce You Divorce, where we discuss topics in divorce that we see our clients struggling with and things that we just want to offer to help you out through this process. So today I'm joined by Dan and Rebecca, and we're going to talk about something that comes up all the time. And while it may seem obvious, it's not always well understood, and the definition and what's going on is not always well communicated. And that is settlement processes, settlement negotiations and divorce. Not everybody, a lot of people come in to the divorce process and they say, look, the reality is I don't like the person right now, but I have children with them. We have business to take care of with dividing our assets. At one point, I actually did like them, and I just want us to be able to move on with our lives happily. So I want to come to an agreement. And most attorneys will agree with you on that. Say, yeah, that's a great idea. Let's start this. Let's start an agreement. But what happens behind the scenes is one idea that we want to talk about. Another idea that we want to talk about is, when do you walk away from the negotiation and say no more? So, Dan, I wanted to start with you. Can you kind of explain to us what a settlement agreement is? A property settlement agreement, custody visitation agreement, or just any agreement in divorce?
Sure. The best agreement that you will have, or you should have, is one that's just going to take care of everything. And what I mean by that is, I'll break it down because not every case will be applicable, but we'll start with custody. So you want to make sure that in a settlement agreement, it has a parenting plan, which is going to define the amount of time that each of you will see your kids or your child, but not just define it in such an ambiguous term as in the parties agree, because I see that way too often. I remember, especially when I was really litigating, someone come in and be like, oh yeah, we're great. I got this agreement, but it says when the parties agree, and I'm supposed to have 50-50, but my ex-spouse says no. So now I haven't seen my kids. And it's like, well, because it says that the parties agree. So de facto, she kind of has full custody or sole custody, depending upon your jurisdiction. So you want to make sure that when you're looking at the parenting plan, you're defining the days and the times and who's picking up and who can pick up and where they can pick up. And if you're going to be late, who do you call? And if you can't exercise your visitation, we call it, where I'm licensed, at right of first refusal. I always encourage clients to put that in there, because if the other spouse can't, or the parent can't watch the kids, then you should have the opportunity to. But you can define that. And sometimes it's, if it's an hour, well, maybe they can just quickly find someone to watch the child for that hour. Or maybe that's something you want, depending upon how far apart you live from one another. But you want to define what that looks like. And then who gets that right of first refusal. But you want to make sure that it doesn't jeopardize or compromise either one of your visitation, because you don't want it to usurp or to take the place of. And then you want to deal with school. I know in one of the states that I'm licensed at, the parents are still liable for education costs, which in a lot of other jurisdictions is kind of silly because they're not. But where I'm at, the Supreme Court basically penalizes you for getting divorced, because they're going to make the parents potentially liable, even though when you're married, you have no liability or obligation really to pay for school. So you want to take that into consideration. And then if that is the case, you want to look at, okay, what does that cost look like if there's any scholarships or loans or anything like that? And then you want to look at college, because again, in some of the states where I'm licensed at, even though you're not a minor when you turn 18, you're still a minor for college purposes. You could be on the hook for college costs. So you want to take, again, scholarships, tuitions, loans, grants, things like that into consideration. Or you want to cap it. I know in one of the states, it's pretty prevalent that in most parenting plans, they'll cap at the cost of the local university, the public school. So you're not being held liable for private school tuition. And then you want to look at, if there's child support, what does that look like? And what factors are you going to take into consideration? And then you want to talk to your attorney, because the number of overnights you have is going to affect the amount of support. So they're working together. On the property side, you want to make sure that you're identifying everything that you're aware of. and that includes debt as well. And you want to try to divide it equitably, which isn't always on a 50-50 basis, but just what's fair. And 50-50 is ideal, but sometimes you can't come to that. And that's okay, because as long as you're coming out somewhat advantageous, then I think it's a good settlement, because there's a lot of give and take, because you have to take into consideration the cost of litigation too. So it's sometimes I'll advise clients that we may be apart by like 10 grand, but if we go to trial, you're going to spend way more than that. And there's no guarantee that we're going to come out ahead. So you want to kind of be smart in the thinking. And then the assets, of course, you're talking about the house and if there's a sale of it and the equity and who's going to get that and what that's going to look like in a division. And then you have retirement accounts, who's going to be, who gets an interest in that, and what does that interest look like? A big mistake, or a common mistake, I should say, that I see a lot of practitioners make, is they don't really cap the retirement interest based upon the length of the marriage as a marital asset. I've had clients come back and it's unfortunately open-ended. So there's so much exposure to it that, I mean, that's just bad news that I have to deliver. So we always want to make sure that we're doing our due diligence. But when a client comes in and they say, we have everything agreed to, I just need you to review this document. Well, there's more follow-up questions that we have. And sometimes the misnomer that clients will have is like, oh, well, just attorneys are trying to spend my time and my money. I said it's going to be uncontested. But we just need to do not only our due diligence, but your due diligence to make sure that there's nothing that we have overlooked, or that there's any exposure, or there's something that maybe you could get a greater interest in if we went to court. So let's try to take advantage of the settlement now. There's just a lot of factors that as practitioners, we want to make sure that we're protecting you. And I know in one of our prior episodes, Rebecca was saying that we may not go to trial, but we want to prepare that we're going to trial. And that's why we're litigators. So it's just being prepared for it. And through that, we're making sure that you're protected. So in an ideal settlement, it's going to take care of everything. So when you come back to modify, it's really just because your parties agree, not because there's an issue that happened with the settlement agreement. And the biggest caution that I really try to explain to clients is once that settlement agreement is signed, it's so hard to get out from underneath it. So you want to make sure before you put your signature on it that you know what your risks are, what your rights are. And even just going back again to what Rebecca was saying, if we went to trial, what does that look like? Because we know as practitioners, based upon the jurisdiction and the court and the judge, what that would look like. And especially if there's an attorney on their side, we know what that attorney would usually try to maybe agree to with his or her clients.
Mm-hmm. Yeah, and there's a lot, right? It's open-ended. Like you said, you can agree to anything as so long as it's not illegal. You know, you were talking about college costs, and I remember we had a client come to us after he signed an agreement, and he was an attorney, and he thought he was the smartest person in the world because he had agreed to no child support, but he was going to pay for college. Well, his daughter wanted to go to like some weird private school that was $60,000 or $70,000 a semester. Well, guess what, man? That was more in child support. And there was no end date. It wasn't if she graduates in 4 years. It was just, I will pay all the cost of college. And this was an attorney that thought that he had really just beat the system. I was like, man, you did not do a good job. And, you know, you talked about something else about we are litigators, so we prepare for trial. And it reminds me, I always think of this old Roman maxim. I'm going to paraphrase it because my Latin's not where it should be. But basically, it was prepare for war to achieve peace, right? You prepare for litigation to achieve the settlement that you should achieve, because if there is no reason for the other side to negotiate, they're not going to negotiate, right? And so, Rebecca, what I want to talk to you about is, you know, Dan did a wonderful job of kind of describing all the agreements we can have. But what goes on behind the scenes? Pull the curtains back a little for us. So a client comes in, client says, look, I want to agree to something. Client leaves. What do you do?
So it depends if the other side is represented or not. But usually what we'll do is reach out to the other side and say, you know, my client wants to make an agreement. They think that we can keep this uncontested. Here are the terms they're willing to agree to. And, you know, if everything looks good to you, sign it, send it back to me. If you've hired an attorney, give this to your attorney, have them call me. And that's usually what that first sort of olive branch is going to look like. Now, depending on what the response is, then it is going to change drastically where we go from there. Sometimes we get a call and it's like, I just want to change this one thing here, maybe tweak one other piece here, boom, boom, and you're done. Very few and far between that it's that simple. Usually there's some big thing, some big source of a disagreement. Maybe someone thinks that you've earned more income. Maybe someone thinks that there should be more money in retirement than what it looks like, that the house is not valued properly. There's usually going to be some large chunk of money that there will be a dispute about. And so at that point, my advice to the client is we don't want to sit here and go back and forth for the next 6 months trying to reach an agreement only to then have to start from square one 6 months from now. We want to go ahead and file the case. We want to start scheduling some court dates. We want to do the discovery, which is where we get information, we get bank statements, we get whatever else there is. And then we can decide, do we keep on having this conversation or do we just go forward with going through court? Because if it's a dispute like, well, there should be more money in retirement. Well, now we have all of the retirement statements and we can decide, is that something that we still need to pursue? Or is this actually a fair agreement at this point? So it's really going to depend, but usually that very first exercise is just, here's what my client is willing to agree to, and they think it's very fair. And let me know if you don't, and get back to me no later than Tuesday, right? There's going to be some sort of deadline in there that we need to have some kind of response. Otherwise, again, we're going to go ahead and file. We're not just going to sit here and let things linger until they finally come to the table and have that conversation. We have to reinforce all the time with our clients that it takes two to settle. So you can want and wish all day long for a settlement, but if the other side isn't going to take that step, if they're not going to come to the table, well, we have to do what we have to do and get your case going.
Mm-hmm. And that's tough to understand, right? Not everybody understands that when you reach out to the opposing side, you said, get back to me on Tuesday. It's not instantaneous, right? No. You send an offer, they look at it for 2 weeks, and then they send something back to you. And then you have to read it to see what's different. Frequently, I'm a big fan of Microsoft Word track changes. I know why attorneys do not like sending contracts back and forth in Microsoft Word track changes. You want to send them in PDF so that they cannot be changed secretly. But you got to go back through and look at it and say, okay, here's where the changes were. And then you have to talk with our client. Say, look, these are where the changes are. This is my legal advice based off what we know so far. Let's make these alterations and then send it back. And so each one of these things, even if you're moving fast, is a week turnaround at each point in time. But it's not a week turnaround because you can get yours turned around tomorrow. Mm-hmm. The other side can sit on it forever. And that's why I'm a big proponent of, Rebecca, you brought up the deadline. I just go ahead and file the complaint for divorce first. Mm-hmm. And then I negotiate, because that way the court has prescribed deadlines that we have to follow, and we don't really run into this stuff and say, look, if you don't want to cooperate, we're just going to move forward with trial. And most of my cases still do settle, right? They do, but they settle to where, our clients want them to settle. So, Dan, you talked a little bit about the cost benefit analysis, right? So you're close and, you're $10,000 apart. And then you're running at this idea of mutually assured destruction, right? Because both parties are going to pay a significant amount of money to go to trial. And a smart client will realize, well, if I've got to pay money to go to trial, so does the other side. So why would I settle? How do you have that conversation?
It's really client management. And it starts, as Rebecca was saying, at that very first initial meeting, setting expectations, knowing what their goals are, and really just trying to advise them what the process looks like. And I get it. They're not trained in the law. And so from their standpoint, it's, hey, why are we doing this? I don't understand. I don't want to spend all this money. I said we're going to be uncontested. Why are you dragging your feet, or why are you trying to drag this out? And it's really just kind of taking a step back. And we talk about it on other episodes that it's showing, it's listening, it's showing that empathy and really trying to understand, okay, where are they coming from? How can I advise them in my role as this is in their best interest? Because at the end of the day, hopefully the client will understand and know that you have their best interest, you have their back, right? Mm-hmm. And so it's tough conversations because you're spending their money, but it's advising them, okay, big picture, yes, we're going to spend a little bit more, but in order to try to facilitate settlement, sometimes we have to be a little bit more proactive. And that doesn't always mean aggressive or coming out with guns blazing. It's just, let's get that ball rolling. And sometimes getting it rolling is, to your point, Charles, filing that action, or to what Rebecca was saying, drafting that letter to the other side, just getting those settlement discussions moving forward. And both of your points are well taken in the sense that it depends on your jurisdiction. If it's not a time sensitive where it's from the date of the marriage until date of separation, I think the approach of trying to resolve it amicably without filing is great. But if it's from date of separation until date of divorce, then maybe we need to pivot and switch. It all really depends, because we just want to make sure that the client knows the longer that you're telling us to wait, you're really exposing yourself to giving up more of the marital interest than what really you need to. And, I'm always a big proponent of discovery. It is a little time sensitive and costs a little bit more, but it opens that door of here is everything that's out on the table. And it allows us to really do that due diligence that we talked about in prior episodes to make sure that we're going through everything and that the client understands what they're either wanting or what they're potentially giving up. And in my experience, throughout the discovery, sessions continue to happen and they get a little bit more productive. And then you may have to go to the next level, which is a deposition, which I'm also a really big proponent and fan of, because it's a great tool to ask questions and to really kind of peek behind that curtain of what's going on and what are you really trying to hide potentially, or what is your true intention. And I usually feel that after the discovery or the deposition phase, we're pretty close to settlement. But that all goes back to what we were saying earlier, that we just want to prepare. And that's why we would call it litigation. And I get it. Clients think, man, that's such a scary big word. All I can think are just dollar signs and time being spent. And my case isn't really getting the attention because the attorneys are racking up their time in the bill. But litigation really just means being properly prepared so we can advise you what is in your best interest.
Yes, it is. So many times I have been on the other end of a settlement agreement where the other side has not prepared for trial and we're headed towards trial. And I will watch the settlement offer start coming back more and more favorably to my client because the other side realizes they can't go to trial and it's already scheduled. They forgot to do discovery because their client was wanting to save money. And I tell my clients, watch, it's going to start falling down. And I had an attorney. It was the day of trial. We had successfully filed motions to block every single piece of evidence they could bring in. They went back to the best offer for my client that she said, she goes, what offer would you take? And I said, the best one I ever wrote for my client. And they signed it. And my client got an offer that we could never have achieved in court because the other side did not prepare for trial. And it wasn't the attorney. It was the client demanding that the attorney not spend the money to prepare for trial. And they lost a lot more money than they would have had they prepared for trial. So, it's horror stories like that in negotiations when you're not preparing, when there's no reason for the other side to negotiate. I knew there was no reason for us to negotiate. The other attorney had her hands tied by her client. She couldn't go to trial. I kept telling my client, like, don't worry. He's like, but trial's tomorrow. I was like, yeah, don't worry. And he's like, but shouldn't we be preparing for trial? And I said, we already have. We've already won it. Don't worry. And, it's the amount of money that he spent on that, he recouped 5 times compared to what the other side saved. So I want to thank both of you for talking about settlement agreements. I think they're tough, and I want to talk to you all next week about settlement agreements and really start exploring this idea of the sunken cost fallacy. So if you enjoyed this episode, please subscribe, leave us comments or questions below. And if you or someone you know is going through the divorce process, give Melone Hatley PC a call and see the difference that a partner can make for you.
Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.